For
What?
we would, if not, we would ask for.
What?
I would ask to pass the matter of brief.
That?
Nobody, Your Honor.
Nobody thought of that on your own?
I did. Yes, Your Honor. I did.
Horrible thought. Why would I pass it? The client's not here.
Your Honor, been unsuccessful in our attempts to contact Ms. Banbury. Last time we were here on May 14th, she was in an inpatient psychiatric ward. We believe that she is not in that ward anymore, but we do not know her whereabouts.
So if I pass it, what are you going to do?
I was going to try to call her one more time.
Don't think that she has appeared in the past.
I think that's true, but I think counsel's right. We figured out at one point she was in a facility. But you don't believe that she's still there.
Do not believe that she is, Your Honor, but we're not positive. So I guess if a bench warrant were to issue, we would try to confirm if she was there and then issue a recall request.
Just asked me to pass it.
Yes, Your Honor.
And then you conceded. I didn't. I was going to give you your way, but you conceded. You want me to issue the bench warrant?
No, Your Honor.
What? I'll pass it. Go make your call.
Thank you, Your Honor.
What was that?
This is just
Yeah. Yeah, you won one.
What?
One.
The only one today.
That's it. I can't wait till your cases get called. Calls case, People State of Michigan versus Paul Ledford.
On behalf of people, Your Honor.
Good morning, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Paul Ledford, who's approaching, Your Honor.
Good morning, sir.
Paul Hayes Ledford.
Thank you.
Discovery is complete. Request and examine this matter, Your Honor.
All right. People have their witness. Who are we doing the 16th? Hold on one second. People have their witnesses available the 16th? All right.
Thank you.
Preliminary examination will be set in person June 16th, 2026, 9 a.m. before Judge Moore.
Thank you, Your Honor.
All right. Thank you. Bond continue. Court calls case People versus Rashawn Bangora.
Morning, Your Honor. And if it's the public defendants, okay, I can rule Your Honor. On behalf of Mr. Rashawn Bangora.
You didn't seem too sure. He's right here.
Oh yeah, I'm here.
Bangora. All right, there you are. State your name.
Arshawn Bangor.
Arshawn.
Arshawn. All right.
Judge, we're asking for an adjournment. There's a potential, I want to look into something a little further before we accept any.
Probable cause conference will be adjourned to June 25th, 2026, 9 a.m.
Thank you, Judge.
Wait. My attorney was supposed to put in a request.
I'm sorry?
My attorney was supposed to put in a request.
Okay.
Put in a request?
That's why
Yeah,
I'm
put in a
asking
request
for
for
the
me to get off
adjournment.
tether.
Oh, I'll have to do a written motion for that.
All right. She's going to file a motion before the court and then I'll hear it, okay?
All right.
Thank you. He's here. What? I haven't walked away. Here. Yeah. I'll send a letter. Okay. Court calls the case, People versus Kristen Luckett. Schnaza?
People.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Luckett, Your Honor. State your name, Mr. Luckett.
Christian David Luckett.
Thank you. This is the confidential one.
Yes, Your Honor. May we approach briefly?
May 26, 9 a.m.
Thank you, Your Honor.
Bond will continue. I. Did. Change my. I'll grin and bear it. We'll talk. The one that, yes. The one that is it. Oh,
Okay, I got you.
so that's why I'm having. One of the many reasons I'm having issues. Court does call the case, People versus Kevin Davis.
Good morning, Your Honor. James Fifelski on behalf of Mr. Davis, who is approaching. You state your name, please.
Kevin Ryan Davis.
Thank you.
Your Honor, discovery is complete and we are asking the court to set this for preliminary examination.
People have their witnesses available the 16th. Preliminary examination will be set June 16th, 2026, 9 a.m. before judge. For me. Bond will continue.
Thank you very much, Your Honor.
Court calls the cases of the People versus Jamari Bagwell.
Bring those for the people, Anna.
Michael Gaddy, Assistant Public. February 26 FB.
And Kyle Burdell on behalf of Mr. Bagwell in matter ending in 0623. Good morning.
Good morning, sir.
And Mr. Bagwell, please say your name for the record.
John Muir Bagwell.
Your Honor,
Oh, so that.
okay, he's acting in absolute wrong order.
All
Bagwell.
Like blocked her out. And like from the back, I'm going, what? Where's she coming from? All right.
Well, Ms. Constantino's here, Judge, because I realize I have a conflict on this matter, and I must withdraw. When the court sees fit, I would like to make a bond argument on behalf of Mr. Bagwell. But also,
Drawing, but you want to make the bond argument. Is that what it is?
what?
Okay, sorry.
The court will hear it. Thank you, Judge. Mr. Bagwell's 35 years old. He has
Okay, so go ahead.
his his children are ages 13, 8, and 3. The 3-year-old is the primary caretaker of his child. The 7-year-old, she's currently in the custody of his brother. It's my understanding that that's not an ideal situation for anybody. He does have a sister. His brother obviously helps him quite a bit. His sister helps him. The mother of his child, he's got friends who are very supportive. We would be okay with the GPS tether. Preferably it would be PR bond, but we did have a discussion with Mr. Bagwell that a GPS tether would be acceptable.
And the public defender would concur with that argument, Jim.
All right. So first of all, is there a response from the people?
People also for its discussion. I would just remind everyone to support that the event does have several.
Does he have a PR on his other cases?
I think of the other case that I have him for, I know he's on a bond violation, I believe. Do you have PRs in your other cases? I believe so, Judge. It's my understanding, yes.
Sure. So, I mean, I guess my question, maybe I'll put it simply, if I were to accede to your request, then would he get out, or we don't know?
You know, let me check. Let me double check. I believe he would get out, Your Honor. I know he has.
Why don't I do this? What are we doing with the case?
We're just getting an adjournment today, Your Honor. Perhaps a nominal cash bond today, so he gets credit if he doesn't get out.
Okay.
Christina Costantino on behalf of Mr. Bagwell, Your Honor. We are asking for an adjournment of the PCC. Given what the court's just heard, I'll be taking over the case. I do need to get discovery in this matter, which I haven't been able to get until now.
Gotcha. So what I'm going to do is this, I will adjourn his cases to the 18th. All right. I will certainly entertain any, I will, at this point, deny without prejudice your request for release. Let's figure out if he would be released and then under what circumstances we could then have him released. I would, you don't want to wait to that date. If a motion comes through, I'll try to hear it on the 11th, a week before. But let's get all the information to me.
First, the existing, it says there's a whole lot of Van Buren. That's the only thing I see. It doesn't say that they're gonna pick them up, though. It's a, looks like a misdemeanor shot. Out of Van Buren town.
Okay, but there's another. Okay, thank you. But my understanding, counsel, is you have him on some other case?
I have him on, he's on probation, Your Honor. It's a probation. So he's not, I don't believe that's keeping him.
Are they holding him on that?
It was a violation for a different, it was a previous violation, Your Honor, for a different issue. And that is, he was released on that case, yes.
Okay. I'm going to do it the way I was doing it. I'll do it the 18th. Sconsino, you can look into that, file the motion, give me everything, and then I can make an informed decision.
Understood.
All right, so at this time, the motions.
Thank you, Judge.
Judge, and just given that, would the court mind scheduling this on the 11th? I know it's only a week away, just so that way we could come back and address that since he is in custody.
All of you are out of control today. Fine. Change it to the 11th.
Thank you, Judge.
Thank you, Judge. Thank
May I approach with a green sheet, Judge?
Really?
Yeah.
It's the coffee.
Mr. Bagwell, I'll see you either.
you. Thank you. Yes, ma'am.
Yes.
Yes. Court calls the case, People versus Daniel Polgar.
Morning, Your Honor. Thank you to the people.
Kyle Burnell on behalf of Mr. Polgar, who is approaching the podium. Mr. Polgar, once you get up here, please state your name for the record.
Daniel Polgar.
Thank you.
And the court should be in receipt of a green sheet. I believe the people are working on some video on their end.
That's fair. We're waiting on CAC's interviews on this matter.
Okay.
Second of those will be taking place on the 15th of this month. I would ask for something towards the end.
Would. Okay, I can do the 25th of this month or the 2nd of next month. Which would you?
Whatever.
I'm here already on the 25th.
Are you?
Yes, Judge.
Oh, joy. No.
Oh, you consolidate. That way you don't have to see me twice. Give me every week. You can put me on the 2nd.
No, that's fine. I don't mind seeing you. You'll be in much better mood now that you're married.
It's funny how that works, Judge.
What?
Funny how that works.
Really is. You just don't know. All right. We'll adjourn this to June 25th, 2026 at 9 a.m.
Thank you, Judge.
Thank you.
Thank you.
Fine, we'll continue. Court calls the case of the People versus Cidalia Benton.
James Feifelsky on behalf of Ms. Bennett. Council approach, please.
Yes, you may.
Thank you.
I ain't gonna say what that's about. It's about the defendant's location. I'll just put it that way. And I will adjourn the probable cause conference out 1 week to the 11th, June 11th, 2026, 9 a.m. Bond will, at this time, will continue.
Thank you, Your Honor.
Thank you. I'm back. There we go. Court does call the cases of the People versus Christopher Madison.
Brandon, over the people, Your Honor.
Ready, Judge. Court shall cease to assistant public defender on behalf of Mr.
Madison, who could be in custody. Your Honor.
State your- Christopher,
Yes,
state your
sir.
name.
Christopher Jerome Madison.
Thank you, sir.
Thank you, Judge. I did have to speak to Mr. Madison a few times over the last few days. His primary concern was he wanted me to address his bond. At this point, we're not ready to proceed, so we'd be asking for an adjournment and for me to address his bond, Your Honor.
And do what?
And for he wanted to address his bond.
All right. I'll adjourn it to June 18th, 2009 a.m. as to bond.
Thank you, Judge. Mr. Madison did indicate that he missed a court date, I believe, and that's why why he was put into custody. He'd be asking the court to consider changing that and allowing him back out of custody. He says that he could afford to pay the bond, but he doesn't have anyone who can go get his money and bring it to the jail to pay it for him. So he's asking the court if the court might consider reducing his bond on possibly a PR bond. He did indicate that I believe he lived at the Defiance Center prior to being incarcerated. And so I think that's all he wants to address today, Your Honor, and leave it there.
Any response from the people?
Court's discussion should give it
Well, a couple things. Didn't appear, and then how did he come back into custody?
Right, he was picked up, Judge. He did not turn himself in.
He was picked up, he did not turn himself in. I'll reconsider it on the 18th, but at this time, motion for bond reduction denied.
Thank you, Judge. Good morning.
Court calls case People versus Joshua Reeve Freeman.
Your Honor, the recognized the practice pursuant to Michigan Court Rule 8.120 under the supervision of forensic custodian attorney Ashley.
Where are you from?
Ireland.
Yes, all right, good. Permission.
Oh, that's auto, then it's automatic.
Yeah.
David I. Goldstein appearing on behalf of the defendant.
Jay Sherry, Freeman.
Thank you. You're requesting an adjournment?
Yes, Your Honor, we have the written discovery, but I just got the videos yesterday, so we need an opportunity to review them. The date that I'm going to be back from vacation is July 2nd.
That's what I tried. All right. I'll adjourn the matter to July 2nd, 2026, 9. Bond continued. All right. Thank you, ma'am.
Oh, I'll do it.
The court does call the case, Full State of Michigan versus Elijah Hudson.
And then on behalf of you, Your Honor.
Mr. Burkett, can you state your appearance, sir?
Yeah, Raymond Burkett on behalf of Mr. Elijah Hudson. Thank you.
Your name?
Elijah, will you introduce yourself to the court?
He did.
Oh, okay. Yeah.
What are we doing?
Okay, Your Honor, at this point, we filed for ask this court to do a competency to stand trial and a criminal responsibility based on my conversations.
So
with
you're asking for forensic evaluation?
Yes. Competency.
I would need I will set it. I'll need the orders in to the court. So forensic evaluation is ordered. I'll set a competency hearing for
September 3rd.
September 3rd, 2026, 9 a.m.
Thank you.
Bond at this time will continue. Thank you. Is this okay? Court does call the case of the people of the state of Michigan versus Svid Pushan.
And then on behalf of you.
Right, stepped out.
All right. While we're waiting for him to come back, can counsel approach, please? Why don't we address at least tangentially the bond violation first? And then
Your Honor, at this time, the people would be asking for the defendant to be placed on a GPS tether within open to the victim's residence. I wanted, the people have learned further information about this bond violation would like to do some further investigations. I think at this time our request will be to add that bond condition of GPS tether.
All right.
Your Honor, I'm going to make a somewhat mild objection, but first I want to address the fact that my understanding is it's already a bench warrant. So if there is, I'm asking that it be canceled. I don't know if it was ever signed. I know.
Yes, it was signed. Off on, and I think entered, was it not? All right. So what I will do, he's here, so I'm gonna cancel the bench warrant.
With regard to the GPS tether, Your Honor, just very briefly, my understanding after reviewing the discovery and having a brief conversation with the complainant, there has been no contact since that time, physical, electronic, in any other way. So I don't know that a GPS tether is really necessary in this situation. And there was no allegation, even in the bond violation, that there was any physical contact. It was the leaving of a voicemail message.
Since I'm adjourning this and accommodating schedules, I will adjourn the probable cause conference to July 2nd, 2026, 9 a.m. With reference to bond, I will cancel the bench warrant. I'll reinstate bond with the previous condition, with his conditions. I will add a BS location correct together with an exclusion zone for the victim's residence.
But no curfew or anything of that nature.
No curfew.
Okay. All right. Thank you, Your Honor.
Thank you. Okay. Court calls case People versus Charles Johnson.
We're not.
Hi, overall, on behalf of Mr. Johnson. Johnson, please state your name for the record.
Charles Bernard Johnson, second.
Thank you.
And Your Honor, may we approach?
I got Polly back on. All right. Court calls the case People versus Josiah Miller.
I should help the people.
David I. Goldstein appearing on behalf of the defendant. I don't see him on the Zoom, Your Honor.
I'm sorry. Okay.
And Your Honor, this was Hillsdale, I believe, County.
Yes.
Last time as well, so. I do know that Mr. Goldstein has spoken with this plan and he tends to wait. I don't know if the court will do it without him being here.
I can't.
Yeah.
Your Honor, I'm going to make a suggestion. I made it to Ms. Feltus, and we both agree it's not the best suggestion, but they're not going to honor a Zoom writ. So I'm asking you set this matter on July 2nd and have the prosecutor issue a corporeal writ, have it brought here. Otherwise, I don't think we're ever going to get it.
I don't have an issue trying for a corporeal writ. I would ask if he could not on the week of the 4th of July, to make it about a month. I know that there tend to be more staffing issues when we have a major holiday coming up. So if we could do the 9th.
The 9th.
All right, let me check that date, Your Honor. Yeah, that's fine.
Turn it to July 9th, 2020. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case People versus Tanya. I'm sorry. Is it Naya Lee? I think.
I should help us for the people.
Morning, Your Honor. Christina Costantino appearing with and on behalf of Nia Lee. Ms. Lee, can you unmute and state your name for the court?
Naya Lee.
Okay, thank you. All right.
Your Honor, we're asking for an adjournment of the PCC. There is a companion case with this case that is scheduled for June 22nd of this year. So we would ask if the court would consider adjourning this PCC to a date after that date.
Oh, it's set elsewhere on the 20th.
Yes, it's set at the circuit court.
Got it. Probable cause conference will be on June 25th,
That works, Judge. Thank you.
2026. Bond continue.
Thank you very much, Judge. Have a good rest of your day.
Is that it for you?
That's it. I'm out of your hair.
Well, no. I just take the rest of these people with you. All right, thank you. Have a great one. Court calls the case, People versus Kyle Pennell.
Good morning, Your Honor. May it please the Honorable Court, David Burge, Kyle Pennell, who's approaching.
Your name?
Kyle Pennell, Your Honor.
Thank you.
Your Honor, discovery is complete. We're requesting to examine this matter.
Would people have their witnesses available the 16th?
We'll do our best, ma'am.
Preliminary examination in this matter will be set June 16th, 2026, 9 a.m. before Judge Moore.
Judge, could I briefly address the issue of bond?
Certainly.
Thank you, Your Honor. Your Honor, bond's currently set in this matter at 500,000 cash surety. Understanding the serious nature of the charge, Your Honor, I have information that the victim in this case, the alleged victim in this case, not only was potentially the initial aggressor, tried to jump in my client's car. Car was the alleged weapon in this case, Your Honor. His injuries sustained were minimal. I think his toe might have been run over at worst, Your Honor. I have text messages from the complaint. He was at the casino the next night and was released from the hospital hours later. Understand, Your Honor, my client does not have a perfect record, but he's been some time since he's had any issue. He does his fiance, Your Honor, who's pregnant, is present in the court today in support of him. They do both reside. He is employed. I'm asking the court to consider at least a reduction in the current bond, again, set at 500,000 cash surety.
Response.
Action.
Does he have other, what's his record like? Because I mean, I'm having some pause on this only because at arraignment, there was a substantial bond that sometimes in and of itself can be unusual.
Are you looking through the criminal history?
Well, for some reason, his bond got set at $500,000.
No.
And Mr. Burgess, properly so, is asking for, in essence, a reduction or his release. But I'm not hearing anything from the people that is telling this court that a $500,000 bond is
What I have.
appropriate. And but somehow at arraignment.
I wasn't present, Your Honor, but
No, and I know, but the people were.
all right.
I'm trying to figure out why was this set at $500,000 if they're gonna leave it to my discretion, because
I see that there is a bench warrant for a probation violation where bond was denied.
so, okay.
And the charges are assault, attempted murder, assault with a dangerous weapon. I am seeing several cases within the last few years. Not all of them have gone to adjudication. But they are either assaultive or firearms.
Is he held on the
Probation violation, Your Honor.
right?
Yes.
Your Honor, yeah, he does have a, I think he's held, but if he's able to post bond, he could address that issue with the sentencing court.
Bond is denied in that.
Who's that before?
It was 14.
So his bond is denied out of 14B.
Yeah, probation judge Washington. Yeah, I think so. Okay. I'm not sure why, Judge. It's a misdemeanor matter.
Has he gone over, is there Does anybody see a date scheduled for him at 14B? Thank you.
You know, she's gonna have the answer.
So he's set to be seen June 25th. You have this on the 16th. His bond isn't gonna be changed there, but
Just facially seems excessive, Your Honor.
it stopped piling on.
Fair enough.
I'm gonna grant a reduction. I do consider this charge as serious, but he's not gonna be going anywhere. It seems at this point. I'll modify his bond. I'll modify it to $100,000 cash surety.
Thank you, Your Honor.
All right. Thank you.
All right. All right. All right.
Court calls case People versus Joshua Hines.
Sherilyn Foster Tucker on behalf of Joshua Hines, who appears on the Zoom.
Mr. Hines, can you state your name?
Joshua Hines, sir.
Thank you.
And Your Honor, we're requesting an adjournment. I just got this case yesterday, so I still need discovery. And if I could briefly address bond.
So.
Your Honor, he does.
Go ahead.
He currently, my understanding is that he's currently testing in Washtenaw County at Community Corrections. He lives in Shiawassee. And he's on
County?
Yes.
Does?
Yes.
Should make her say Shiawassee. No.
And he's on probation out of Shiawassee County. And so he is hoping to get it so that he can test. He's testing in Shiawassee County and has signed a release of information. So he's hoping to be able to continue doing the testing there and not have to drive the hour to Community Corrections to do his testing here and repeat it.
Understood.
Yes.
I'll adjourn the matter to June 25th, 2026, 9 a.m. I will prepare an order for the court. I will sign off on an order allowing him to test in Shiawassee County.
Okay.
As a release of information provided to Community Corrections here so we can see the results.
Okay. Thank you, Your Honor.
Thank you. Court calls the case People versus Wesley Brand.
People.
Assistant Public Defender Dante Lebo for Ms. Brand.
Your name, sir? Wesley Brand.
Andrew, and I believed I had a green sheet, but it just went missing. Yeah, and we'd be requesting an adjournment order in order for Mr. Brand to review the video in this matter, which I received yesterday.
You received the video yesterday. He needs to see it.
Yes, Your Honor.
We get all that done by the 18th?
I don't see why not.
All right. Probable cause conference in this matter, June 18th, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls the case People versus Kelly Ott.
People.
Sherilyn Foster Tucker on behalf of Kelly Ott.
Hello, Your Honor.
Hello. State your name for me, please.
My name is Kelly Ott.
Thank you.
And Your Honor, we're requesting an adjournment. Mr. Bernstein is still needs discovery to review it.
That objection, I'll adjourn this matter June 25th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court
Thank
calls
you, Your
case versus- You're welcome, ma'am. Court calls the case versus Shelby Barber.
Me, Assistant Public Defender, could not be here yet. Really, Your Honor, on behalf of Ms. Shelby Barber. Mr. Shelby Barber.
When you know, all right.
Judge, I have not
If
made,
you walk slow and talk slow, that doesn't make them appear.
I was hoping something was gonna happen, but today's not the day. Your Honor, I have not been able to make contact with Mr. Barber, I'd be asked for an adjournment.
Bench warrant will issue for defendant failure to appear. Bond will be set amount of 10,000 cash surety.
Thank you, Judge.
Court does to the people of the state of Michigan versus Stephen Douglas Wainwright cases.
That's developed for the people.
What started as a routine probable cause conference quickly turned into a series of tense courtroom moments involving witness intimidation allegations, missed court appearances, and a judge forced to make difficult decisions. One of the most serious hearings involved Dion Bransford. Prosecutors informed the court that while in custody, Bransford had allegedly been contacting the victim through jail phone calls and even asking other inmates to contact witnesses on his behalf. According to the prosecutor, some calls included discussions about convincing witnesses to change statements given to police. The allegations immediately raised concerns about witness tampering and interference with an ongoing criminal case. Defense counsel argued that if any violation occurred, the court should simply issue a warning rather than impose additional restrictions. But the judge wasn't willing to ignore the accusations. While further investigations remained ongoing, the court took immediate action by revoking Bransford's phone and texting privileges inside the jail. Prosecutors also revealed that additional criminal charges could potentially follow if investigators confirmed witness intimidation efforts. The decision sent a clear message that attempts to influence witnesses would be treated very seriously. Later in the hearing, another defendant failed to appear in court altogether. After waiting and hearing from defense counsel, the judge lost patience and issued a bench warrant for the defendant's arrest. A cash bond was set, ensuring that the missed court appearance would carry immediate consequences. The moment served as a reminder that failing to appear before the court can quickly turn a manageable legal situation into a much bigger problem. The session also featured several bond hearings where defendants requested release from custody. In one case, a man facing serious charges asked the court to reduce a bond that had originally been set at an astonishing $500,000. After reviewing the circumstances, the defendant's criminal history, and the fact that he was already being held on another matter, the judge concluded that the original amount appeared excessive. The court ultimately reduced the bond to $100,000, while still recognizing the seriousness of the allegations. By the end of the day, the courtroom delivered a powerful lesson about accountability. Whether dealing with witness contact, bond violations, missed court dates, or release requests, the judge made one thing clear. Every action has consequences, and every decision can dramatically affect the outcome of a case. Do you think defendants accused of contacting witnesses should immediately lose communication privileges while their cases are pending?